Welcome all. Today we will see the class on Law of Treaties. This is Dr. K. Sangeeta for Public International Law. Importance of Law of Treaties. Introduction. All kind of interstate transactions are conducted through treaties. Various international organizations are established by means of treaties. Dispute between states are brought before international court by means of treaties. Treaty is the most important source of international law, and the special importance of treaties is international law does not need emphasis. We will see the Vienna Convention on Law of Treaties 1969. The main reference to this area of law is the Vienna Convention on Law of Treaties 1969. It was adopted on 23rd May 1969 and it was entered into force on 27 January 1980. It is a combination of codification and progressive development of international law. Definition of treaty. Swishenberger, a treaty may be defined as a consensual engagement which subjects of international law have undertaken towards one another with the intent to create legal obligation under international law. According to Oppenheim, international treaty or agreements on a contractual character between the states or organization of state, creating legal rights and obligation between the parties. When you see Article 2, the purpose of the present convention, treaty means an international agreement concluded between states in written form, and it is governed by international law, whether embedded in a single instrument or two or more related instruments, and whatever its particular designation. Article 3 states the fact that the present convention does not apply to international agreement concluded between states and other subjects of international law or between such other subjects of international law or to international agreement not in written form shall not affect first the legal force of such agreement. The traditional definition, the definition of treaty under Article 2 of the Vienna Convention distinguishes two respects. First one, it deals only with treaties concluded between states. This is because there is a separate convention on the law of treaties to which international organizations are parties. Second one, the convention is limited to written treaties only. However, it is not intended to deny the legal effect of the oral agreement under international law. When you analyze the definition of the treaty, the Vienna Convention expressed to be for the purpose of the convention and it's limited by the treaty between the states. The following is an examination of the elements of definition of treaty under the Vienna Convention as supplemented by the customary law. An agreement concluded between states, treaty making capacity. Article 6 of the convention, which provides that state makes treaties, reflects customary international law. Capacity to make treaties is in fact valuable evidence of statehood. Federal state, Article 6, Para 2 of the draft article, which states that members of the Federal Union may possess a capacity to conclude treaties if such capacity is admitted by the Federal Constitution and within the limits of their laid down. International organization. The Vienna Convention on Law of Treaties 1969 is limited to treaties to which states are parties. It does not cover treaties to which public international organizations are parties. A special convention on the law of treaties between the states and the international organization or between international organization was signed in 1986. Individuals have never been recognized as having the capacity to make treaties. Even transnational corporations have no such capacity. In the Anglo-Iranian Oil Company case in 1952, the ICJ held that a contract between the Iran and the Anglo-Iranian Oil Company was not a treaty. It is nothing more than a concessionary contract between a government and the foreign company. In written form, the Vienna Convention does not apply to oral agreements, although such agreements are valid under customary international law. Even though the traditional practice is for the original text of the treaty to be typed and printed, There is no reason why a treaty should not be contained in a telegram, telex, fax message, or even email, or rather constituted by an exchange of such communication. Governed by international law, there may be an agreement between the states, agreement for the acquisition of the premises of a diplomatic mission for some purely commercial transaction. They are regulated by the local law of one of the parties or by the conflict of law principle. The notion of international agreement for the purpose of law of treaty is confined to one of the whole formation and execution of which is governed by international law. Intention to create legal obligation. From the practical point of view, the decisive factor is whether the instrument is intended to create international legal rights and obligation between the parties. This element of intention to create legal obligation under international law can be found in traditional definition of treaty by eminent writers, but it is not expressly mentioned in the definition of the treaty by the Vienna Convention. The element of the intention is included in the phrase governed by international law. If you see the Aegean Sea continental shelf case, this could be understood. Whether embodied in the single instrument or two or more related instruments, the classic form of a treaty is a single instrument. However, in modern practice, treaties are made in less formal ways, such as exchange of notes or exchange of letters. An exchange of notes usually consists of an initial note by one state and the reply note by the other state. In other words, it consists of two related instruments. The above phrase clearly acknowledges the validity of increasing use of such exchange of note and letters in the modern treaty practice.